Good morning, Miss Frame. Will you take the oath? I swear by Almighty God
I swear by Almighty God
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Miss Graham.
Thank you. Good morning, Miss Frame.
Good morning, Miss Green.
You are Kate Frame.
Yes,
What age are you?
64.
And you worked with Crown Office, I understand, for 28 years.
I did, yes.
And you were a fiscal, a qualified lawyer for
Yes.
that period of time. And at the end of your career, you worked as head of criminal allegations against the police division.
I did, yes.
Is that called Cap D?
It is.
We've heard of someone called Les Brown, and we've seen some correspondence from Mr. Brown. My understanding that was that he took over as head of Cap D. Is that correct?
That's correct.
Did he actually take over from you?
I think he did, yes.
Right, thank you. What did that work involve, being the head of Cap D?
Receiving allegations about the police, various allegations in relation to their interaction with the public and the complaints that had been made about them of a criminal nature.
And was that all criminal allegations, as it says in the title?
Yes,
So things like excessive use of force, that type of thing?
yes,
Assaults, maybe?
yes, indeed.
Thank you. And then, as I understand it, you became the Police Investigations and Review Commissioner from August 2014.
Yes,
And you held that role until August 2019.
that's correct.
And am I right to say that you then retired?
Yes, I did.
Thank you. Now, just to clear something up, some people in the past have talked about the Police Investigations and Review Commission, but my understanding is that's not correct.
It's
And
not-
actually it's the Police Investigations and Review Commissioner.
That's correct. Yes.
So when we talk about the PIRC, we're actually making a reference to the role of Commissioner
Yes,
rather than a body known as the Commission.
that's correct. Yes,
And that was your role, you were the Commissioner.
I was.
Thank you. And in May 2015, which is obviously the time scale we're looking at here, you were the Commissioner at that time.
Yes.
What did your role as Commissioner actually cover? What did it involve?
Well, it was the strategic oversight in relation to both the complaint handling review section and the investigations team.
Miss Frame, I wonder if you could pull the microphone a little more
Yes.
close to you, please.
Certainly.
So it was the strategic oversight.
Of the complaints handling review business and also the independent investigations section.
Thank you. And did it involve work? I think in your statement you talk about it involved planning and direction.
Yes.
What did that actually consist of?
Well, planning the business, and some of that involved the resourcing of the organisation and reviewing the powers that were available in the legislation.
Right. And when you mentioned direction in your statement, what did that cover?
Well, the strategic direction of the organisation and the corporate objectives and the business planning around that.
What were the corporate objectives? Do you remember now?
And I'm sorry, I don't.
Right. Can you think of anything that would have amounted to the one corporate objective? Can you give us an example?
Well, to undertake effective and independent investigations.
Right. Thank you. And we'll come on to this in a moment, but we've heard that investigations carried out by PIRC had to be Article 2 compliant.
Yes.
Thank you. So in terms of your role as Commissioner, you weren't a hands-on investigator.
No, there were a team of investigators with trainee investigators, then investigators, deputy senior investigators, a head of investigations, and then the director of investigations.
we've heard that you were obviously at the top as Commissioner, and that in terms of the top of the investigations team, that there was the Director who was John Mitchell
Yes.
in May 2015. There was then Irene Scullion, who was the head of
Yes.
investigations. And then senior investigators included people like Richard Casey
Yes.
and Mr. McSporran.
That's right.
And then the deputy senior investigators included Mr. Little
Yes.
and Mr. Harrower.
Yes.
Thank you.
I think there was a third senior investigator as well, a Mr. Meterer.
Right, thank you. Oh, we've heard his name as well. Now, I don't know if you've had any opportunity to see evidence from other witnesses.
I've seen clips on the news website.
Well, you may, although you may not have seen a blue folder being referred to, and I see it's in front of you on the desk.
Yes.
And just to explain the setup here, when I ask you to maybe refer to a document or a paragraph in your statement, it'll come up on the screen in front of you.
Okay.
That's so everyone in the room can see what I'm referring to.
Thank you.
But in addition to that, you have a hard copy of your statement and
Yes.
anything else, which will be in the blue folder. Now, please feel free, if you're one of those people that prefer hard copies, please feel free to refer to that. If you're comfortable looking at the screen, we can go through it that way.
Okay.
But if there's anything that I don't refer to, that doesn't come up on the screen, that you think might be of help in explaining a position or what happened, please feel free to look through your hard copy, and if you mention the paragraph number, we can bring that up.
Thank you.
And the other thing that occasionally happens is witnesses will sometimes say, oh, there was an email or there was a document that would be very helpful to the chair. If I don't have that available to put on the screen, we can get it at the next break or overnight.
Okay.
So please feel free to let me know if there's anything like that. And let's look first of all at your inquiry statement, which is SBPI 00447. And you'll see that's come up on the screen. And this is the the witness statement that you've given to the inquiry. And it was taken by a member of the team over a number of days. And if we look at the final page, you'll see that this is 173 pages long.
Yes.
And if we go to the bottom of that page, right to the bottom please, you'll see that there's an area for signature
Yes.
of the witness. Now, on the screen, you'll see that your signature's been redacted, so no one can see that. And it's dated the 22nd of January of this year.
Yes.
But on your copy, I think you should be able to see that you've actually signed every page of the statement.
Yes, I see that. Yeah.
Thank you. And if we look at the final paragraph, which is 795, I believe the facts stated in this witness statement are true. I understand that this statement may form part of the evidence before the inquiry and be published on the inquiry's website. And you understood that to be the case when you signed.
I did, yes.
I would like to begin by asking you about a couple of documents that we've heard evidence about already, so I won't go through them in a lot of detail with you, but they should be documents you're familiar with. The first is PIRC 04446, and as I say, you've been asked about this in your inquiry statement. And you see on that page there, it says it's dated 12th of November 2012. So it's prior to you coming into the role of Commissioner
Yes.
in 2014. Actually prior to PIRC being created, which we've heard was on the 1st of April 2013.
Yes.
And if we can look down the page, please, it's headed up Police Investigations and Review Commissioner, Operational Model, Response to Article 2 Investigations. And if we can turn on to page 2, do you recognise this document?
Yes, I do.
And the section I'm interested in is at paragraph 5, and it starts, we see it on the bottom of the screen, the Human Rights Act 1998. and obligations imposed under Article 2 apply equally to Police Scotland, Crown Office and PIRC. And we've heard evidence from John Mitchell that it applied equally to all three of those organisations, if I can call it that.
Yes, that would be my understanding too.
Thank you. And John Mitchell explained that where Article 2 is engaged, all three had a duty to ensure that they conducted themselves in a manner consistent with the 5 procedural obligations that the courts have held to exist.
Yes.
Is that also your understanding?
It is, yes.
And then there are 5 procedural obligations listed in this document. First of all, the investigation must be independent insofar as it should have no hierarchical or institutional connection to those implicated. The investigation must be effective. The investigation must be reasonably prompt. There must be a sufficient element of public scrutiny. The next of kin must be involved to an appropriate extent. So those are the 5 procedural obligations, and they're set out in this document.
Yes.
And as I understand it, to have an Article 2 compliant investigation, which was the aim of PIRC, is that those 5 procedural obligations will be satisfied.
Yes, that's right.
Thank you. And that document remained in force in May 2015, as I understand.
Yes, it did.
Thank you. And then can we very quickly look at the second document, which is PIRC 04453, and this is a memorandum of understanding, and it's between the Crown Office and the Commissioner.
Yes.
And if we could look at page 2 of this document, and I should say, without needing to go to the last page on the screen, this was signed by both the Crown and the Commissioner in December of 2013.
Yes, and it was shared with me when PIRC came into being as the head of the criminal allegations against the police division.
So in your role as head of CAPD, you actually had sight of this before you even became the Commissioner.
I did, yes.
Thank you. I'm interested in looking at page 2 and primarily about section 2, paragraph 2.1, please. There we are. We've heard some evidence about this. There's a reference here to section 33A of the 2006 Act. It details the general functions of the Commissioner as follows. So at the time this document was entered into, you weren't the Commissioner at that time.
No, I wasn't.
Although you did subsequently become the Commissioner.
Yes.
Did you have some input into this document in your role in Crown Office?
I think I saw a draft before it was signed off by the Crown Agent.
All right, thank you. And we'll see, I don't need to look at paragraph A, but we've heard something about paragraph B. And this is about directions from a prosecutor. So it's a Crown-led investigation. Mm-hmm. And we've heard there's a distinction to be drawn between a Chief Constable referral and a Crown-led investigation.
Yes.
So this is section B, or subsection B, I should say, relates to the Crown-led. And the Roman numeral 1, to investigate any circumstances in which there is an indication that a person serving with the police may have committed an offence. And then B, over the Roman numeral 2, to investigate on behalf of the relevant Procurator Fiscal the circumstances of any death involving a person serving with the police, which that Procurator Fiscal is required to investigate under Section 1 of the Fatal Accidents and Sudden Deaths Inquiry Scotland Act 1976.
Yes.
And just so everyone is clear, if there is a death in custody or a death after police contact, that would be something that the Fiscal would be required to investigate.
Yes.
Regardless of whether there are any allegations of criminal activity.
That's right, yes.
So we've heard some evidence that B1 relates to possible criminal activity and B2 relates to this investigating the circumstances of a death.
Yes.
Would you agree with that?
I would, yes.
Thank you. let's look at B1 first of all. To investigate any circumstances in which there is an indication that a person serving with the police may have committed an offence. So that's a criminal offence.
Yes.
Where it says an indication that a person serving with the police may have committed an offence, could you help me understand what level or degree of evidence would be required to meet that test or that threshold under B1?
Well, as part of that, if we were advancing to consider the allegation, there would naturally be a time where you consider whether the person was a witness or a suspect. And to move to the threshold of a suspect, you would require a reasonable suspicion that they were involved or that they were involved in the crime.
Right. We've heard some evidence already from others. I've asked witnesses about this changing of status from witness to suspect.
Yes.
And a number of witnesses have referred us to a test called, were there reasonable grounds for suspecting
Yes.
that the witness or the officer had committed a criminal offence?
Yes.
So they've referred to this phrase, reasonable grounds for suspecting.
Yes.
And I'm wondering, in paragraph B, Roman numeral 1, where it says an indication that a person serving with the police may have committed an offence, to what extent does that differ from reasonable grounds for suspecting an officer had committed a criminal offence?
Well, at the stage of indication, it would be an investigation where the person necessarily wouldn't necessarily be a suspect.
So an indication means you don't have to be a suspect.
That's right.
So an indication can be less than reasonable grounds to suspect.
Yes.
Right. And can you help the chair understand what type of evidence may be an indication rather than reasonable grounds for suspecting?
The starting point would be an allegation and something to support that.
And when you say something to support, can you help us understand what that would be?
Another adminical.
Would that be one witness?
It could be.
What else could it be?
Potentially, I was going to say CCTV footage, but if it was on CCTV footage, it probably would be accepted as supporting the allegation if the allegation was seen to play out on the CCTV.
Right. So it could be a witness, it could be CCTV. Any other examples you can think of at this stage?
I'm sorry, I can't
That's
remember.
fine. So indication is something less than reasonable grounds to suspect. So there is a difference between those two. Can you help me understand that what PIRC would do if they start off looking at a B2, investigating circumstances of a death,
Yes.
and at some point in the course of that investigation there is an indication that a person serving with the police may have committed an offence?
There would be the option of going back to the Crown to seek a alternative direction in relation to that, and to let them know that there had been that indication, so that they were aware of what the investigation had uncovered.
And what difference did it make to a PIRC investigation if it was under B2 or B1 in terms of the practicalities of that?
Very little, I would suggest, because given the nature, particularly of a death in custody, there would be a full investigation, And if the investigation revealed criminality, then we would just advance that as a criminal investigation. So the full circumstances would be explored.
So can you then explain if the status of someone is, if we're in a situation where it's either, say, a B2, and the person is being treated as a witness,
Yes.
and then there a situation arises where it now appears there's an indication that the person may have committed an offence. One option is to go to the Crown and ask for your terms of reference or your direction to be changed. What happens to the status of the person?
Their status, if there is the reasonable grounds to suspect, would change to being a suspect if we had reached that level.
So you've said that indication is some sort of adminicle of evidence exists that would amount to an indication. But you've also said if there's reasonable grounds to suspect, their status would change. So can a person's status change if there is something akin to an indication as opposed to something akin to reasonable grounds to suspect?
I would suggest that the reasonable grounds to suspect would be a little more than an indication.
And can you give us an example so we can understand what are reasonable grounds to suspect? What would you need for the reasonable grounds to suspect threshold to be met so as to change a person's status from witness to suspect?
I think there would require to be the circumstances which would cause a reasonable person to have that suspicion.
Right. And how does that differ from an indication?
There's probably little in it.
Right. It may be that there is a definition of reasonable suspicion that presupposes the existence of facts or information which would satisfy an objective observer that the person concerned may have committed the offence. And I'm wondering if that's far removed from an indication or not.
From my own perspective, it's perhaps marginal but slightly more.
Right. Are you looking for corroboration with reasonable grounds?
No.
So it can be on the basis of one witness, reasonable grounds to suspect.
It could be.
And that could also be the case with an indication.
Yes.
Or it could be CCTV.
Yes.
Can you think of an example which will assist the chair in understanding that marginal difference?
I'm trying to think back to specific examples, and right now I can't.
Right. Well, if something does come to you during the course of today, you can share that with us.
Thank you.
Would in under B1, presumably, if the prosecutor asks PIRC to investigate in circumstances where there is an indication that a person may have committed an offence, at that stage, if that investigation comes into PIRC under B1, does that automatically mean that the officer is a suspect?
Again, I think that would depend on the circumstances that were available.
Right. So it could be a case where the indication is actually quite a substantial body of evidence.
Well, yes.
Or not?
Not
Would it be a
slightly
question
weaker.
of degree? Sorry, I didn't hear that.
Yes, slightly weaker. It could be either a lot of evidence that makes it very clear, or it could be weaker than that.
Right. So it would depend on an assessment of the evidence that was available.
Yes.
And if it amounted to reasonable grounds for suspicion, then that person could have their status changed to suspect.
That's right.
Thank you. Can we move on to section 5 on page 4? And in particular, I'm interested in 5.4, which is at the, 5.5, which is at the bottom of the screen. And again, we see here that PIRC investigations are intended to comply with the 5 principles of effective investigation outlined by ECHR, namely independence, adequacy, promptness, and so far as possible, public scrutiny and victim involvement. And we've heard that that effectively mirrors what was said in the previous document that we looked at.
Yes, it does.
So again, a reference to the 5
Principles,
obligations under the Article 2. What I intend to do when I ask you questions today is really to look at some of these principles and ask you questions about each area. But first of all, in relation to the events on the 3rd of May 2015, we have heard that that was a bank holiday weekend.
Yes.
It was a Monday holiday, and not everyone was in the office working. Some were on call, some were away on holidays, having a holiday weekend. And I wonder if you could explain to the chair, when was your first attendance at the office that after Mr. Bio had died?
On the 4th of the Monday,
On the
the Monday which was the bank holiday, I was in for a short time, and I appreciate that I actually went back in the following day as well for a very brief time, literally for the briefing, and then left.
Right. And we've heard that Mr. Harrower was the lead investigator on the 3rd. He was on call.
Yes.
And it was him with a team from PIRC who went to Kirkcaldy Police Office on the
Yes.
Sunday. We've heard that then Billy Little was lead investigator on the Monday.
Yes.
That was the 4th. And did you see Mr. Little on the 4th when you were briefly in the office?
Yes, I did. On the 4th, I was in for longer than I was on the 5th. I actually had confused the days, I'm sorry, and had thought that I was only in on the Monday, which I appreciate now, having looked back at my own records, that I was back in on the Tuesday.
Right. So, and when you say you were back in on the Tuesday, was that for part of a day or a full day?
No, it was simply for the briefing, the update.
Right. And then when did you return to the office, sort of for a full day?
That would be the following week.
Right. So, for the remainder of that week, were you aware that Mr. McSporran had essentially taken over the lead investigator role?
No, I didn't appreciate that until I returned to the office.
Right. So were you aware that Mr. Harrower had gone in on the Sunday and then Mr. Little had taken over as lead investigator on the Monday?
Yes.
Thank you. And am I right in saying that there are at that time at least, there were actually 2 offices?
Yes, that's right.
Can you explain that to the chair?
The investigations team were located in Hamilton House, and my understanding is that the review team were originally based there, and when the organisation was expanded, they actually moved to Bothwell House, and the investigations team took over a larger section of Hamilton House, and the corporate services division was also located in Bothwell House.
And as commissioner, were you based in Boswell House or Hamilton House?
In Bothwell House.
Bothwell, sorry. You were in Bothwell House, and the investigations team, they were in
They were in the other building.
Hamilton House. geographically, was there much between those buildings, or were they close together?
No, they were located fairly close together.
And when you went in on the 4th, the Monday,
Yes.
bank holiday, did you go to your office in Bothwell House or to Hamilton House?
I went initially to my office and then went up at some point to the investigations team.
At Hamilton House?
At Hamilton House, yes.
And then when you were in on Tuesday, again, was that to your office or to Hamilton House, or both?
To both.
To both. Was it something that you commonly did where you moved between the buildings?
Yes.
I'd like to, when did you find out about the death of Mr. Bio?
On the I heard reporting of the incident on the Sunday morning quite early on. I wasn't aware that there had been a death at that stage.
Right.
I think that related to the injury of a police officer that was being covered in the media at that stage.
We've heard from other witnesses at the inquiry that there was a media story on the radio that a female officer had been stabbed.
Yes.
We've heard that wasn't the case, but that was an initial story that had gone out on the radio.
Mm-hmm.
Is that what you're referring to?
Yes, I can't remember the actual injury. I just remember that there was coverage that an officer had been injured in the course of her duties and taken to hospital.
Thank you. So when did you hear of Mr. Bio's death?
At around lunchtime when Mrs. Scullion contacted me.
And was that on the Sunday?
Yes.
And is that Irene Scullion, who was the head
Yes,
of
it is.
investigations? We'll maybe come on to that later on. But first of all, to go back to the five principles,
Mm-hmm.
can I ask you about the first of those principles, independence?
Mm-hmm.
I've asked previous witnesses who were working at the time about any contact or prior contact they'd had with officers who were part of the investigation initially.
Mm-hmm.
Now, having looked at your statement, I think there was nothing of note as such in terms of the contact you had had,
Mm-hmm.
either as Commissioner or in your former role as head of Cap D, with any of the police officers who were part of the initial investigation into Mr. Bio's death.
Mm-hmm.
But can I just check with you, did you have any prior contact or knowledge of ACC Nicholson, Rudy Nicholson?
Yes, I had met him before.
And when you say you'd met him, what sort of meeting or meetings had you had with him?
He had been involved in an investigation, part of which what he was conducting in one of the offices, or not in one of the offices, in the geographical location where I was at the time, and he discussed various aspects of the investigation.
And Gary McEwen, had you?
I don't know, I hadn't met him.
Leslie Bowl?
Yes, I had met her in connection with some policy matters.
And the SIO was Pat Campbell. Did you know him?
Similarly, I had met him again in connection with various policy matters.
And of any of these officers, had you had anything amounting to significant contact or prolonged contact?
No, it was limited in relation to all three.
And was this when you were head of Cap D?
No, in relation to each of them, it was in connection with just general operational business as part of the Crown Office and Procurator Fiscal Service.
So in terms of any of them, what was the most recent contact you'd had with any of them prior to the 3rd of May 2015?
A number of years.
Right. Thank you. We've heard evidence about the impact of, if I can summarise it as limited or limitations on the resources available to PIRC
Yes.
in May 2015. We've heard that in any investigation there may be a need to rely on Police Scotland officers to assist, for example, with house-to-house inquiries.
Yes.
And we've heard evidence that, at least initially, until PIRC arrive, that police officers, there is an expectation that they will secure the scene and deal with matters at that initial stage.
Yes.
Is that your understanding?
Yes, there's a responsibility or an expectation, as you say, in relation to the level of cooperation in connection with the securing of evidence and the scene, and also the initial operational response.
Did you have any concerns, thinking about independence of the investigation, did you have any concerns at that stage about the impact that reliance on Police Scotland had on the independence of a PIRC investigation?
I think from a public perception, it was difficult. However, the way that these incidents are reported in Scotland, generally to the police, they will be the first on the scene, and then Crown Office can take the decision and make an assessment as to whether PIRC should become involved.
Looking back now, with the benefit of hindsight, can you see any routes or any ways that that could be improved to minimise or avoid the need to rely on Police Scotland officers? Once PIRC have been instructed to investigate.
If there were PIRC investigators available close by to minimise the time that Police Scotland officers were left in charge of the scene, for example, that would assist in reducing that reliance.
And minimising that geographical location, are you thinking having PIRC investigators spread around the country?
Well, potentially satellite offices, yes.
Right. Was that something you considered when you were Commissioner?
It was discussed, but the resources for that just were not available to us to put that into being.
All right, thank you. If there was such a thing as satellite offices for PIRC investigators, you think that would benefit or reduce the delay in investigators attending a scene, or do you think it would reduce the need to rely on Police Scotland officers, or both?
Potentially both, because you would expect the PIRC investigators to be on the scene more quickly and thereafter to be in a position to take charge and direct any investigation from that point.
Right, thank you. Now, the other thing that you mention in your statement is that resources were a matter of concern to you, and they were underestimated from the outset. And you've talked about resources being part of your remit as Commissioner.
Yes.
And I'm interested in to what extent you formed the view that resources were inadequate from the outset.
I thought that given the geographical spread and the potential for the volume, and certainly as time went on, the complexity of the cases that were being referred, that the demand would outstrip the resources.
Do you remember when you took over in 2014, to what extent was it anticipated that PIRC would be handling investigations, and what number of investigations was it anticipated they would deal with?
I can't remember the precise number apart from what Crown Office thought, and my understanding was that they anticipated that there was going to be less than a handful, so less than 5 referred per year. And in my last year, my recollection is that there were 36 Crown-directed investigations referred.
And on top of the Crown-directed investigations, were there also Chief Constable direct?
Yes, there were Chief Constable referrals and also referrals from the SPA, the Scottish Police Authority.
And you explained to us earlier that you retired in August 2019.
Yes.
And when you say your last year, are you talking about that period 2018 to 2019?
Yes, the financial year 2018-19, yes.
When did the financial year end?
in April of that year.
So it would have been April 18 to April 19.
Yes,
And there were 36, did you say?
that's right, yeah.
Crown led. Recognising that there were concerns about resources and the adequacy of resources, can you explain to us what discussions you had about funding or improving those resources once you were enrolled?
Yes. There were regular discussions with the Scottish Government sponsor team. We met with them, I think it was quarterly, and they were provided with updates in relation to the volume and also the types and complexities of cases that were being referred.
At what stage did you start asking for additional resources?
I think the first evidenced budget bid that I put in was in, I think it was either August or October 2015. We had been told before that my predecessor had applied for resources in the first year of the organisation's existence and sought further funding for the investigation team. And at that stage, some money was provided. It was for fixed-term investigators. I think 3 fixed-term investigators were to be funded, and the Commissioner was advised that the other 3 had to be found from within the PIRC's own budget. At that time, he was also advised that it was extremely unlikely that there would be any further increase in the grant in aid for a further 2 years. So the general feeling within the management team at that stage was that there was an extreme unlikelihood that any funding would even be considered before the 2 years were up. And in fact, within my first, certainly, month of the appointment, one of the first meetings I had was with the Scottish Government sponsor team to look at business efficiency in recognition of the fact that this funding had been provided. So in 2015, I appreciated that I was moving ahead of their anticipated schedule and sought funding at that stage. And my recollection is that the funding that was provided was sufficient to employ the 6 fixed-term investigators that we had previously had on our books. And I think there was money for 2 further investigators, so an uplift of a further 2, and I think money for 2 trainees as well.
Right. So let's just recap over in relation to that. You come into post in August 2014.
Yes.
At that stage, your predecessor had been to the Scottish Government to ask for additional funding already.
And that's great.
3 fixed-term investigators funding had been given for those, and a recognition that PIRC would have to find space or resources within their own existing budget
Yes.
for the other 3 that were requested.
Mm-hmm.
So he'd requested 6, got funding for 3, and PIRC had to find a space for money for 3 themselves. You came in August 2014, but then within a month had a meeting about business efficiencies with the Scottish Government.
Yes.
We've then heard that Mr. Bio died in May 2015, and we've also heard that around about the July there was the M9 fatal crash.
Yes.
And I think Mr. Little, amongst others, have talked about the demand on resources at that time for PIRC was significant.
Yes.
And you said that in 2015 you went, I think you went back to ask for more funding.
I did.
Was that before or after Mr. Bio died?
I think it was just after.
Before the M9 crash?
I think it was after both of those.
Right.
So it was either from memory, it was either the August or the October I submitted the bid.
So within about a year of you taking up your role.
Yes.
And as a result of that bid for additional funding, you were given funding for 6 investigators. 3 you'd already had, but 6 in total. 2 further investigators and 2 trainees.
Yes.
And was that in recognition of the demand on resources that PIRC were suffering from at that time in 2015?
Yes, there was a considerable amount of evidence put forward, and it took quite a lot of work, both in the investigations team, to compile that and also to provide an illustration, I suppose, of the complexities of the case, because numbers are one thing, but the actual level of investigation for some, in particular the Crown-led investigations, was significantly more, in most cases, than the referrals that we received.
So they were generally the more complex investigations anyway.
Yes.
And you said by the year from 2018 to the end of the financial year in 2019,
Yes.
you had 36.
Crown-led.
Crown-led.
Yeah. I think in total that year there were 67 investigations.
And what had been your estimation, or what was the estimation of the workload for PIRC when you took over the role in 2014? In terms of the number of investigations, total?
I can't remember. I don't know if I ever saw the figures for the estimated volume. I know that there had been considerable difficulties in assessing that volume, simply because the different police forces had recorded matters that would, in the new era, if we could call it that, would be referred to the PIRC. So there was a discrepancy in how those matters were recorded. There was also a discrepancy in various approaches by different forces as to when they would have brought in other forces to investigate matters that would now come to the PIRC.
We heard evidence from one witness who said the prior legacy forces, before Police Scotland came into existence in April 2013, had assessed numbers differently, and it made it difficult to work out what the overall estimate would be for
That's right, and I think it was recognised there was that difficulty in coming up with a finite number that could be anticipated, and on that basis the Scottish Government, their view was that the first few years would be an opportunity to assess the consistency and the level of demand, so that obviously funding could be increased if required.
And so essentially once you came into position, an assessment was done and further resources were actually sought.
Yes.
The following year.
Indeed. I should say that in relation to the funding that was provided, even though, or my recollection is that even though it was sought in August or October 2015, because of the spending review, my recollection is the money was not provided until the following year, so March 2016.
Right. We've also heard evidence that at a point in time of the investigation into Mr. Bio's death, that in fact the members of case handling review team were used as to bolster the investigation team numbers. Do you remember that?
Yes, I do remember that, because on my return to the office, Mr. Mitchell and I sat down to assess what we could do to supplement the investigation team. There were effectively 2 options that we considered. One that was put on the table, but one which I thought was fundamentally naive, would have been the secondment of police officers. We both, I think, considered that would compromise the independence of the organisation. So the only other option that we came up with was to second effectively or designate the complaint handling review team members, which we were successful in doing.
We've heard that around 6 of them were then sent out with an investigator.
That's right. I think they undertook, from memory, I think they undertook the house-to-house inquiries.
Right. And although they didn't necessarily have investigation experience, they could effectively corroborate what was being done by the investigator.
That's right.
Sticking with the issue of independence, we've also heard some evidence that connects to the post-mortem that was carried out on Mr. Bile. Now, I appreciate you say that this happened on the 4th of May. You said you were in the office for a brief period during that day. I think in your inquiry statement you do say that you had spoken to, is it Dave Green from Crown Office?
Yes, Mr. Green, yeah.
And you were aware of the family's wishes, and by that, am I understanding you understood and were aware that Mr. Bile's family wished his mother to come up from London?
I remember
prior to identifying the body at a post-mortem.
Yes, I think my recollection is that it was family members. I don't recall it being tied to just the mother coming.
Was the mother to be part of that group, or
yes,
as well as others?
Yes, I understood that to be the case.
How did you become aware of the family's wishes?
I think that information was shared with me by Mr. Little.
When was that? Do you remember?
That would be on the morning of the 4th.
When you were in the office or on the telephone?
In the office. I recall he actually came down to my office.
Right. And was that your office in the other building?
Yes.
And was that prior to the post-mortem having been carried out?
Yes, it was.
And tell us about your discussion with Mr. Green at Crown Office.
Well, I was aware from Mr. Little that Crown Office, and I didn't know precisely who had been made aware of this issue, and I wanted to ensure that he, as the head of the what was the deaths unit before this, was aware of the circumstances so that that could be considered.
What did you tell Mr. Green?
My recollection is that I told him that the family had indicated that they wanted other family members present before any post-mortem went ahead.
And what was his response?
I think he was trying to balance the need for to see if a cause of death could be ascertained against that. But the eventual outcome was that the post-mortem had been arranged by that time and was to continue.
What efforts did you make to persuade him to delay the post-mortem?
I tried, well, I did explain to him that the family's wishes were for it to be delayed until other family members had arrived. Unfortunately, there was no indication of when that would happen. So I suppose his view was, how long was the post-mortem to be delayed for? And we didn't have that information.
Is that information that you could have obtained?
Well, I'd understood that that information had been sought but hadn't been provided.
How did you understand that?
I think, again, that was from conversation either with Mr. Little or another member of the investigation team. I don't recall precisely who.
Was that conversation in your office or was it in the other building?
I think that could have been in the other building.
And when you say it may have been Mr. Little, it may have been someone else, who else could it have been?
Other members of the investigation team who were present that morning.
Was there any attempt to speak to the flow? We've heard from Mr. Lewis that he was appointed as a family liaison officer on the 4th. And was there any attempt to involve the flow to see if you could get more information from the family?
I don't recall being aware that Mr. Lewis at that stage had been appointed as the flow.
Right. And how long were you in the office that day? Do you remember?
I would say a couple of hours.
And you spoke to Mr. Little in your office, and you may have spoken to others in the other office.
Yes.
Was it Hamilton?
Yes, Hamilton House.
Do you remember the identification of any other investigators you spoke to apart from Mr. Little?
Who were present that
Yes.
morning?
On the 4th.
I don't now. No, I'm sorry, I don't.
All right. Can I ask you about something else we've heard some evidence about? I think you've been asked about this in your inquiry statement. We've heard that there were a number of police officers present at the post-mortem. Now, this took place on the 4th of May, and we've heard from Mr. Little about this. And I think you say in your statement that wasn't common for police officers to be present.
Well, yes, I should perhaps clarify that.
I wondered if you would.
Yes, it wasn't common in PIRC. In fact, it had never happened that I was aware of in a PIRC investigation, but in being asked about police officers being present at postmortems, they frequently were present at postmortems when I was a fiscal.
Right. So, leaving aside the involvement of police officers who may be part of an investigation when you were a fiscal,
Yes.
and just focusing on a PIRC investigation, are you saying that it had never happened?
I wasn't
as you're
aware of it ever having happened before.
Thinking about this requirement of independence of the PIRC investigation, would you have had, did you know on the 4th, before the post-mortem was due to take place, that there would be police officers present?
I can't remember that.
Had you known, would you have had concerns?
Yes.
Can you explain to us why?
Well, I would have thought it was inappropriate for the police officers to be present, potentially as members of that Fife division were involved in the incident.
And if you had been in a situation where you had known, been aware that officers were present, what were your expectations of your investigators? What would you have expected them to do at the post-mortem if they were present and realised officers were there?
I think they could have raised concerns, but my understanding is that at postmortems they are convened at the hand of the Crown, and anyone present is there under the direction of a Crown office.
And in terms of PIRC and the obligations for independence and securing that independence, what expectations would you have had of your investigators about protecting that independence?
I think it potentially should have, and it may well have been, raised or challenged with the Crown.
So if there was an investigator there, we've heard the lead investigator was there, would you have expected them to raise that with the Crown? We've heard that a fiscal was there, Mr. Ablett was present.
Right.
So would you have expected them to?
I would have expected some discussion around that, yes.
Thank you. Would it surprise you to know that there were no concerns raised at that time by people from PIRC, investigators from PIRC?
Yes, it would.
And you would be concerned why?
Again, because of the question of any interference with the independence.
Thank you. We've also heard evidence that later that day, at least later that day, there was a discussion about disclosing some of the preliminary findings of the post-mortem to police officers. You're nodding. I think you've been asked about this in your statement. Can I ask you, again, thinking about this from the perspective of independence, can you tell us about any concerns you have about that?
I think the senior investigator found himself in a very difficult position, but from my perspective, it would have been preferable for that not to have been shared.
And when you say it would have been preferable not to have been shared, if you'd been in that position, what would your instruction have been?
Well, I wouldn't have shared it with him.
And can you explain why you would have taken that view, not to share that information?
Because that formed part of the PIRC investigation and was not information for the police or Police Scotland.
The officers who were under investigation?
Well, generally I would have taken the view that Police Scotland should not have been party to that at that time.
We've also heard that by the 4th of May and the date of the post-mortem, no information had come from the officers regarding initial basic facts, initial accounts, no statements had been taken. Is that something that would have caused you concern about sharing or disclosing information about the post-mortem prior to obtaining statements?
Yes.
What would your concerns have been about that?
Potentially that the officers could have tailored their statements.
And when you say they could have tailored their statements, what do you actually mean?
Well, they could have adapted them in light of the information that they've been provided.
And that's something you would have wanted to avoid, presumably?
Yes.
Can I move on to the question of adequacy? That's a big word. And we have heard that on the 5th of May, that Crown Office sent the first letter of instruction to PIRC. So this would be the Tuesday.
Yes.
I think you said you were in at some point for a period. So on that day, the Crown Office, in terms of reference, expanded to include the whole circumstances. Up until that point, it had been split. Some have called it a parallel investigation, but there'd been the early matters leading up to Hayfield Road were dealt with by Police Scotland, and from Police Scotland, from Hayfield Road onwards,
Yes.
PIRC were dealing with the matter. But on the 5th of May, the whole thing was combined and PIRC took over. Are you aware of that?
I am, yes.
We know that Billy Little was lead investigator on the 4th, but John McSporran came back to work on the 5th, and within a period of time he was lead investigator. He was also a senior investigator at that time, as I understand it.
Yes.
Billy Little was a deputy senior investigator at
Yes,
that
I think
time.
that's right, yeah.
We have heard that police had delivered statements that were taken when they were in charge of the investigation in lead up to Hayfield Road. And we heard evidence from Mr. McSporran that PIRC were then in the process of obtaining statements themselves from certain witnesses. That was on the 5th of May. And I asked him about a couple of statements in particular that were taken on the 5th of May, one from Ashley Wise and one from Kevin Nelson. And they were both described as eyewitnesses. At that time, at least, they lived in Hayfield Road, in the area of where the incident had occurred.
Okay.
And Mr. McSporran gave evidence that, well, in relation to those two statements, they were taken by PIRC investigators in the evening, I think they started at 7:20. But he would have expected by the 6th, the morning of the 6th, that those two key statements would have been brought to his attention, and he remembered reading them. He would have had copies of those statements. So I looked with Mr. McSpadden at what was available to PIRC on the 6th of May. And part of that body of evidence that was being gathered in included the statements of Ashley Wise and Kevin Nelson. Do you remember their names?
I vaguely remember their names. I wouldn't be able to say what they spoke to.
That's fine. So I looked with Mr. McSpadden at a sort of snapshot, if you like, of where the investigation was on the 6th of May. So not in the initial days, but 3 days after the death of Mr. Bio. And perhaps we could look, first of all, at Ashley Wise's statement, and that hopefully will refresh your memory.
Okay.
It's already on the screen. You'll see at the top of it, it says Ashley Wise, and then it's taken on the 5th of May at 7:20 in the evening by investigator Alex Maguire. Do you remember him?
Yes, I do.
And he was there in the presence of DSI Margaret Ann Hedrick. So he's in the presence of, do you remember Margaret Hedrick?
I do, yes.
And I'd like to go through some of that statement with you. And just give me a moment. Could we look at, I'm interested in pages 2 and 3 effectively. So if we can start with page 2. Now I'm not going to go through every single paragraph. I'm going to begin at paragraph 6, which starts, what it looked like to me. I'm not going to go through every single paragraph of the statement. I'm going to extract certain elements of it. And I'll go on and develop some questions with
Okay.
that in mind. So paragraph 6, which begins, what it looked like to me, was that I saw a police officer striking the man on his legs to get him down. I'm not sure whether he was completely lying down on the ground or was going down at that point. There was at least 6 police officers lying on top of him. They were crossing over him from both sides. They pretty much covered his whole body. It was only when they moved that I could see his arm, and definitely knew it was a black man. It looked like one officer was using a baton to hold the man down. It was on his upper chest, towards his throat. And then looking at the next paragraph, when the man was on the ground, the police officers were on top of them. I could see him struggling with them, and they put tape around his feet and legs. When the man was on the ground, I heard him screaming. It was a horrible sound. It sent chills through me. I heard the man shout to the police to get off him. They never moved from him at that point. I think the black man was on his back when lying on the ground. I'm not sure if he was moved whilst on the ground. I saw him lying on the ground. I could see his wrists were restrained. His hands, arms were in front of him. The police officers were still lying on top of him. There seemed to be a pause or a break. If we can move on to the next page, page 3. Second paragraph there. I think the police officers were lying on top of him a long time. I think it was at least 5 minutes they were lying on top of him. It may have been about 10 minutes. This includes the time when he was being taped to his legs. At all times he was surrounded by police officers. There were at least 6 police officers around him at all times. So can you see the sort of content? Very briefly, I'm just giving you the content of
Yes.
Ashley Wise's statement. Do you remember that statement now that I've read those passages out to you?
No, I don't.
No. Then let's look at, let's see. Can we look at the Kevin Nelson statement, please? PIRC 00019. You'll see this is Kevin Nelson. It's taken on the 5th of May at 7 o'clock in the evening by investigator Karine Pattenden. Do you remember her?
Yes, I do.
And a DSI Brian Dodd.
Yes.
Do you remember him? And if we can look at page 2, please, of his inquiry his PIRC statement. I'm looking towards the bottom, the third paragraph from the bottom of page 2, and it starts, when this male, there it is, when this male started walking along the road, he appeared to be acting as if the police were not talking to him. He ignored everything that was being said. My view is clear. I would say the male was about 30 yards from me, and at this time he did not appear to be carrying anything in either of his hands. He heard a male officer shouting, "Get down." And then can we move on to page 3, please? And I want to start with the paragraph you see at the bottom of the page, the black male. He then stepped forward towards the female officer and had appeared to lunge at her with his left fist towards her face, head area. I believe he struck at her with his closed fists at least 3 times. I heard her scream out, so I cannot be positive, but I believe that at least one of those fists struck her. He then left his window. He went to the front garden to have a closer look. Took him 10 to 20 seconds. And then the next paragraph. In this time, the black male now appeared to be face down on the pavement to the left of my house on my my side of the street. I could no longer get a clear view of this male. There appeared to be 5 or 6 male police officers attempting to restrain him. All of these officers were dressed in uniform. I observed one officer appeared to be kneeling on the ground with the weight of his upper body by use of his arms to the black male's shoulder or back of neck area. I would not be able to describe this police officer. The other police officers appeared to be laying across the black male's body. So there's 5 or 6 male officers attempting to restrain him. One is kneeling on the ground with the weight of his upper body by the use of his arms to the black male's shoulder or back of neck area. The other officers appear to be laying across the black male's body. Do you see that? Now that I've shown you that, do you remember this statement?
I do, yes.
Right. And this is Mr. McSwannon had this available to him on the 6th of May.
Mm-hmm.
So this is before you have any statements from the police officers. Mm-hmm. There's nothing at all from them at that stage. Mm-hmm. But you have these 2 statements from eyewitnesses. And you may recall Ashley Wise was the witness who took the Snapchat footage,
oh, yes,
which was available as well. Mm-hmm. We have heard evidence that police officers have the legal right to use force.
Yes.
And even deadly force in certain circumstances.
Yes.
But in order for that use of force to be legitimate, that they have to justify that.
Yes.
And we've heard evidence that justification for use of force is by showing that it's reasonable, necessary and proportionate.
Yes.
And officers have to use the absolute minimum force that they can.
Yes.
To achieve their objective.
Yes. Mm-hmm.
And they have to have precluded other less forceful options, either having tried and failed or having ruled them out for depending on the reasons and the circumstances.
Yes, I'm aware of that.
Now, at this stage on the 6th of May, there is absolutely no justification being provided by the officers for any use of force. What PIRC do have on the 6th of May are these 2 statements from Ashley Wise with her Snapchat footage and Kevin Nelson. And as I've shown you, Ashley Wise has spoken about one officer, looking like one officer was using a baton to hold the man down on his upper chest towards his throat, and officers lying on top of him for 5 minutes, maybe 10 minutes. And Kevin Nelson talking about the man walking along the road, ignoring what was being said, not holding anything in his hands. He spoke about him being face down on the pavement with 5 or 6 male officers attempting to restrain him. One kneeling on the ground with the weight of his upper body by use of his arms to the back of the male's shoulder or back of neck area. And the other officers laying across the black male's body. So I've condensed those, but that's
Yeah.
the sections. We also have heard evidence that there was a statement from DC Connell, who was a police officer who had attended the scene at Hayfield Road, and he had found a knife some distance from where the incident occurred.
Yes.
And Mr. McSporran talked about it. It appeared to him at that stage there was an inference that perhaps Mr. Bow was not in possession of a knife at that time.
Yes.
When it happened. Now, we've also, with Mr. McSporran, looked at the Officer Safety Training Manual that was in place in 2015. And it was actually a 2013 manual. And I wonder if we could look at that. PS 10938. And if we could look at page 29 of the PDF, which is page 23 of the manual. There we are. This is Module 1, Medical Conditions and Considerations. We've heard evidence that this is the manual that was used for officer safety training at the time that this incident took place.
Okay.
And I'd just like to go through some of this with you. So officers are obviously in their training and in their recertification training taught about safe methods of restraint, safe ways that they can use force.
Yes.
And we've heard that a number of the investigators were former police officers and had had that type of training. If we can look at the page on the screen, medical conditions and considerations. Two specific medical conditions, namely positional asphyxia, restraint-related asphyxia and excited delirium, must be recognised by police officers when dealing with a subject. I'm particularly interested in the positional asphyxia. And this is part of the training delivered to officers at that time. Positional asphyxia, restraint-related asphyxia. This can occur when a subject is placed in a position which interferes with the ability to breathe. Death can occur rapidly, and it may be the case that a police officer can be found to be liable. Risk factors which contribute to the condition are then listed. There's a number of bullet points listed there.
Yeah.
The body position, which can result in partial or complete airway constriction. Alcohol or drug intoxication is a major risk factor. Inability to escape. The subject is prone, so on their front. Obesity, age, stress, respiratory muscle fatigue related to prior violent muscular activity, such as fighting with police officers.
Yes.
So these are named risk factors for positional asphyxia. And as it says above, this death can occur rapidly with positional asphyxia. And if we look at the right-hand column, it then gives a list of signs and symptoms. Officers should recognise the following symptoms and be prepared to administer emergency first aid. Body position restricted to prone, face down. Cyanosis, gurgling, gasping sounds. An active subject suddenly changes to passive or loud. Panic, verbalising that they can't breathe. It goes on to say when a subject has been involved in a physical and violent struggle, the exertion involved causes the muscles to use oxygen at an increased rate. The process can cause oxygen debt in the muscles, and the physiological response to that is accelerated breathing. When a subject is restrained, ventilation, the process of getting air into and out of the lungs can become more difficult due to the internal organs exerting pressure on the diaphragm. This is particularly evident when a subject is placed in the prone position or pressed against a surface. If the subject's hands are restrained to the rear, breathing ability may be restricted, has to be considered. And if we can move down. The process of restraining often requires the upper body to be held down, sometimes by an officer's own body weight. This chain of events may trigger positional asphyxia. Officers are encouraged to remove the subject from the prone position as soon as possible following restraint. The subject can then breathe without restriction, and the officer can still carry out search procedures before executing the safe get-up technique. So you'll see that that section alone talks about various risks,
Yes.
signs and symptoms to be conscious of, and the need to get the subject essentially out of the prone position as soon as possible following restraint.
Uh-huh.
There's no safe period of time given that an officer can keep a person in the prone position for 3 minutes or 4 minutes and it'll all be safe.
Yes.
There's an explanation that death can occur suddenly. And if these risk factors are there, these are significant because
Yes.
they could result in death. So again, on the 6th of May, the PIRC have 2 statements taken by eyewitnesses giving a description of the restraint. They have no justification from the police officers as to any justification for use of force. PIRC are also aware that CS spray and Pava spray have been used because items were left at the scene.
Yes.
So at this stage, there is clearly that there has been a use of force and there's no justification. The postmortem has been carried out on the 4th of May, but cause of death at that stage is unascertained.
Yes.
And there's further tests to be carried out, toxicology and,
I remember those, yes.
things of that sort. We have heard evidence from Mr. Little that he had spoken to the pathologist after the postmortem, and what had been ruled out was blunt force trauma to the head. But nothing else had been ruled out as a cause or contributory cause.
Yes.
Positional asphyxia had not been ruled out. Mechanical asphyxia had not been ruled out.
Yes.
And the impact of the restraint had not been ruled out as a cause of death. So I spoke to Mr. McSporran about this, and the references in the statement from Ashley Wise, the baton being used to hold the man down towards his throat area. Ashley Wise saying it lasted for about 5 or 10, maybe 10 minutes. I asked Mr. McSporran about Kevin Nelson talking about 5 or 6 officers trying to restrain the man, one kneeling on the ground with the weight of his upper body, using his arms to the back of the male's shoulder, back or the back of his neck area, and 4 or 5 other officers laying over his body. And I asked him what his views were about the investigation at that stage, where he had those 2 statements. This was the training that was given to officers at the time.
Yeah.
Positional asphyxia, restraints not being ruled out as a cause of death. And I asked him at what stage, where was he with the investigation then at that point? I don't know if at that stage you were aware of the evidence you had available
No.
to your investigators. But in light of what I've told you was available on the 6th of May from Miss Wise and Mr. Nelson against that background, can you tell me what your thoughts were about the way the investigation was going at that point? Now, at this stage, it's into the circumstances. It's not a B1. There were no indications at the initial instruction from Crown that there'd been criminal activity. But where was the investigation at that point?
Well, I wasn't in the office at that time,
No,
but
but
looking
I'm
at it on a
asking you-
theoretical basis, yes.
Yes, obviously, I appreciate you weren't there. And I appreciate that this was not something you were party to discussions to, but as Commissioner, and obviously having been head of Cat D, I'm interested in where you think the investigation was on the 6th of May. Looking at it now.
In terms of the actual terms of reference provided by Crown Office, my recollection is that it was referred as a Section 33A with no further specification of it being a B1 or B2.
Right.
So it could at any point have moved between those two. And my expectation is that the investigation would continue with a view to clarifying what had happened.
And to what extent would you expect the investigation continue at that point?
Well, I think there were further witnesses to be seen, but additionally, potentially advising a Crown Office in relation to the witness statements that had been obtained.
And what would you be expecting your investigators to advise Crown Office?
Of the content of those statements, to allow a consideration to be made as to whether they wished it to be refined further.
And when you say refined further, what would the options have been at that point?
To consider whether it continued as I think the verbal instruction had been to investigate the death, and or alternatively to consider whether there was the potential for that being considered as a B1.
So I think the understanding of the investigators that they were to investigate the circumstances initially of Mr. Bayo's death.
Mm-hmm.
But do you think on the 6th of May it would have been possible for investigators to go back to the Crown and say, do you wish to consider whether this should be a B1, an investigation into potential criminal activity?
I think the potential for that was open to them, yes.
Thank you. We've heard they didn't do that.
Mm-hmm.
Does that surprise you?
I think in terms of the original instruction and the terms of reference provided, because they were so broad, I don't know, but I would think that they may have felt that 33A encompassed both.
I don't think we've heard any evidence to suggest that they thought it encompassed both.
Mm-hmm.
I'll be corrected if I'm wrong,
Mm-hmm.
but my understanding is the investigators thought they were doing a B2 investigation into the circumstances of the death.
Yes, well, I agree. That was my understanding. They were doing an investigation into the death. But given the fact that Crown Office had left it open as a 33A, they hadn't pinned it to either a B1 or a B2. So in those circumstances, it was maybe felt, and I'm speculating here, that the 33A was capable of encompassing both. That's perhaps a better way of putting it.
Right. Was it common for the Crown Office to just refer to Section 33A and not pin it to B1 or B2?
No, from recollection, this is the only investigation that I can recall that it's been left as wide.
At any stage did you consider, when you became involved, going to Crown and asking for them to be specific about that position?
We had meetings with Crown Office staff on a regular basis, and the impression that I gained was that it was being, and this may have been based on the fact that the verbal instruction was into the death, that it was a death investigation. And indeed, from recollection, there was a further meeting in relation to some additional points that were referred to us. And there was some dubiety as to whether or not they should, on our part, as to how they should be advanced. And from recollection, my memory is that they were to be tied to the original instruction, which was continuing as the death investigation.
I'll maybe come back to that. Thank
Okay.
you. I wonder if that would be an appropriate.
We'll take a
stage.
break for 20 minutes. Ms. Graham.
Thank you. So just to recap very slightly, we were looking at the 6th of May.
Yes.
I appreciate you weren't in the office that day. But in terms of your view as Commissioner at that time, would you have expected your investigators to go to Crown Office, advise them as to the statements of Ashley Wise and Kevin Nelson, and would you have expected them to raise the issue of maybe changing it to a B1 investigation with the Crown at that time?
I think my point before we broke was because it was a 33A and it had been left open as either a B1 or B2, but on the understanding that the investigation was progressing as a death investigation, it would have been an option to go back to Crown Office and make them aware of the content of those statements.
And aware of the progress that was being made with the investigation?
Yes, and there were updates provided to Crown Office throughout this.
So if you'd been asked for your advice as Commissioner on that day, what would your advice have been for your investigators?
It probably would have been to disclose the contents of those statements to Crown Office, to allow further consideration to be given as to whether they wish to refine the terms of reference.
And if you'd been head of Cap D at that time and received a call from PIRC, what would your position have been?
That's quite a difficult question to answer. I think there's potentially an indication there from the content of those statements. However, the investigation was ongoing. I recall that the CCTV did not support the length of time, I don't think, that was referred to by Ashley Wise in relation to the restraint. It probably is a reasonable example of a distinction between an indication and reasonable cause to suspect.
And if you'd been asked to express a view as head of Cap D, what would your view have been about whether it was reasonable cause to suspect or an indication?
I think I'd have been inclined to the fact that it would be an indication.
So it would have become a B1 investigation rather than the B2?
Potentially, yes.
Right. And can I ask about status of the officers at that time?
Mm-hmm.
What were your expectations of your investigators in relation to considering on the 6th of May the status of the officers? We've heard that this can be from moving them from witness to suspect.
Mm-hmm.
And the test was reasonable grounds for suspecting criminal
Yes.
activity.
Mm-hmm.
Would you have expected your investigators to consider the status of the officers on the 6th of May in light of the information they did have?
Yes, I would expect them to be considering that throughout the investigation.
And if you'd been asked for advice about the status of the officers on the 6th of May, what would your views have been as Commissioner?
I think from the information you have given me there's a question in relation to which officers were performing what action. So it may not have been possible to identify who was actually undertaking the actions described.
Would that have made a difference?
I think you'd need to identify who it was that you were moving to potentially a suspect category.
And would you have considered the implications of concert?
Yes, potentially.
And if you'd been asked to consider the issue of officers acting in concert,
Mm-hmm.
Tell us what your views would have been about the implications of that in regard to the question of status.
I think I'd have needed to see how or what level of engagement there had been by which officers to determine, first of all, if they had all been acting in concert.
How would you have got that additional information?
Ideally from CCTV footage or Ashley Wise, but my recollection is that neither were particularly clear.
Would you have gone back for further statements to seek that information?
Yes, that would have been another option, yes.
Is that something you would have expected your investigators to consider doing?
If there were issues that required clarification, yes.
Sorry, I thought you said you would have expected to identify or be in a position to identify which officers were doing which action. Was
Yeah.
that a point that needed clarified?
Well,
Sorry, am I misunderstanding?
In relation to individual officers and their actions, if they had all been acting together in concert, that would have been, I suppose, one way that it could have been advanced. The other would have been to look at individual actions.
All right. So if the view was taken that the officers were acting in concert, would the individual actions have been less significant to a consideration of whether they should be suspects?
I think much would depend on what those actions were.
Well, assuming the actions are as described by Ashley Wise and Kevin Nelson in their statements, would they be less significant if they were all acting in concert?
No.
So you still would have wanted to identify the individual actions of individual officers?
I would want to know who was involved, yes.
Would you have expected your investigators to have a discussion in the office, perhaps, of the status of the officers and to note that down? Different considerations, how they came to a view not to change the status of the officers on the 6th of May.
That was something that could have been considered, yes.
If that had been considered, would you expect the outcome of that discussion or consideration to have been noted down somewhere?
Yes.
Where would that be?
In a policy log.
We've heard about something called the management policy log. Would that be the type
Yes.
of a document that would note down considerations such as that?
Yes, and the rationale behind it.
We've heard that part of it is about the decision, and then there's a section for giving reasons why.
Yes, that's right.
Is that the type of
Yes.
document? And I asked Mr. McSpadden about these matters when he gave evidence on the 16th of February. He said, in reply to my questions about this, that we would need to wait for the results of the final post-mortem to determine whether asphyxiation was a contributory cause, and that was going to come several weeks later. Do you agree that it was necessary to consider the final post-mortem before any decision was taken about, for example, the status of the officers?
I'm not sure. I'd need to reflect on that.
All right, we can come back
Thank
to
you.
that. Mr. McSpadden, when I asked him about this, took the view that without a confirmed cause of death, the PIRC investigation would need to continue to gather in more evidence, either to support or disprove the versions given by Ashley Wise and Kevin Nelson. Do you agree with that?
I'm sorry, could you repeat that?
Yeah. I spoke to Mr. McSporran about this in evidence, and he was of the view, as I understand his evidence, that without a confirmed cause of death, which wasn't available on the 6th of May, it was inconclusive at that time.
Yes.
The PIRC investigation would need to continue to gather in more evidence to either support the versions of Ashley Wise and Kevin Nelson or to disprove the versions of Ashley Wise and Kevin Nelson. Do you agree with that?
I think the cause of death would be important in relation to determining what the potential crime would be, rather than proving or disproving a witness's testimony.
Right, thank you. And if that cause of death is significant in relation to the ultimate charge or crime that is being alleged, is it fair to say that that is not necessary to a consideration of the status of the officers? That's separate from consideration of their status.
You would require to have a suspicion of a particular crime.
Right.
So the cause of death would link to that.
Could that crime be excessive use of force by officers rather than a crime of excessive use of force which caused a death?
Well, yes, and I think that's perhaps the distinction I was seeking to draw there, yes.
Right. So it would be possible to consider status of officers, bearing in mind a crime of excessive use of force. It wouldn't be necessary to prove cause of death in order to consider status.
Yes.
And as I understand it, and from your experience, am I correct in saying that any use of force which is not justified or which is excessive
Yes.
is not a legal use of force?
Yes, that's
and
right.
as such is a potential criminal activity.
Yes.
If I told you that there was nothing in the management policy log detailing a consideration of the status of police officers, considering whether they met the threshold, that there hadn't been an approach to Crown Office at that time, would that surprise you that none of that was done?
Yes, it should.
And would you have concerns that it wasn't done? We're obviously talking about adequacy of the investigation here, one of the 5 principles.
I think if a policy log had been initiated and there was a significant consideration such as that, I would have expected that to be contained in the policy log.
Right, thank you. There certainly was a policy log. We've gone through a number of entries in relation to that. There's nothing on the 6th of May in relation to this
Right.
question having been considered.
Okay.
And we've heard evidence from Mr. McSporran, who was the lead investigator at that time. I asked him, did you consider at that point, talking about the 6th of May, because you had those 2 statements, that's Ashley Wise and Kevin Nelson, changing the status of the officers? And he said no. And I asked him if he'd considered that, and he said no, they hadn't considered that. He gave evidence on day 83 that we did not know whether the restraint contributed to the death or otherwise. He said 2 people had saw the restraint. It was obviously a restraint on the ground. There was a struggle. But as we say, we wanted to know how long did that occur. Could that have contributed to the death? And that would come through pathology and other mechanisms, which wasn't available, the final postmortem at that time. Do you agree with his emphasis on the restraint and cause of death as being significant against the background of considering status?
No, I think it sounds from what you're saying that he was solely considering a death rather than other potential options.
Thank you. Can I move on and ask you to look at a notebook dated the 14th of May? So this moves on from, we were talking about the 6th of May a moment ago. We're now moving on to the 14th of May, just over a week later. And if we look at COPFS 04609, and these are handwritten notes which we understand are an extract from Lindsay Miller's notebook. You know Lindsay Miller from Crown Office?
Yes, I do.
And you'll see it says meeting with the PIRC, 14th of May 2015. LA, which I understand stands for Lord Advocate, who at that time I think was Frank Mulholland.
Yes.
John Mitchell, who was your Director of Operations. Investigations, sorry. Les Brown, who we've heard took over as Head of CAPD when you left, and yourself, Kate Frame, as the Commissioner. And Lindsay Miller's initials are also there. And you'll see that these are handwritten notes. We could just scan through the first 2 pages. There's initials in the left that indicate who was speaking or the point raised, and then some notes taken of the meeting on the right. You see that?
Yep.
Can we look at the beginning of that section? If you can just give me a moment to find my copy. Sorry. Do you see that the first entry at the top of that page is against the initials LA for Lord Advocate? Do you see that?
Yeah.
Disgrace, no statements provided, should be suspended. That was a comment made from the Lord Advocate. Do you remember this meeting?
I do remember the meeting, yes.
And John Mitchell is noted as having said, I don't disagree. Can you move down to, you'll see there's a section with a line next to it. Just under that line says JM, John Mitchell, may need, if we can stop there, may need to detain and interview under caution. This is a carbon copy of the Duggan scenario. There's an asterisk, but independent confirmation of his actings. Can I ask you about the comment made by John Mitchell? May need to detain and interview under caution. Can I ask you first of all to explain to the people listening what an interview under caution is?
An interview under caution would take place when someone is a suspect, they're afforded their rights and advised that they don't need to say anything in response, and are provided with the opportunity to seek legal advice. And
you've mentioned already, is that at the stage the person being interviewed is a suspect?
Yes.
So they're no longer, if they ever were, a witness. At that stage, if someone is a suspect and being interviewed under caution, there are reasonable grounds to consider they've committed a criminal offence.
Yes.
And there's no reference there to you having commented about that or responded to that. Can you tell us what your views were at that stage when John Mitchell raised the issue with the Lord Advocate, we may need to detain and interview under caution?
I don't recall that comment to start off with, and I'm not sure where it was considered or what Mr. Mitchell had in his mind in relation to considering the officers as suspects. I don't know if he was aware at that stage. Obviously that may have taken place. He may have had the statements shared with him the previous week. I don't know. I hadn't had that discussion with him.
Right. And, well, certainly PIRC had Ashley Wise and Kevin Nelson's statement.
Yes, I
and on the
appreciate that.
14th of May, there were no statements provided by the officers
Yes.
on that date.
Mhm.
So you don't know what he was meaning then when he spoke about that?
No, I didn't know what he's basing that comment on.
We've not heard the evidence from Mr. Mitchell in relation to this passage. If part of that is based on the statements of Ashley Wise and Mr. Nelson, had you considered whether there would be a need by the 14th of May to consider detaining officers and interviewing them under caution?
No, my recollection, I was just almost back from leave, and the meeting had been arranged with the Lord Advocate, so I was literally into the meeting almost within a day or so of returning.
Had you not been briefed prior to going for a meeting with the Lord Advocate?
I had been updated in relation to what had taken place, but I don't recall any information being provided in relation to either Ashley Wise or Kevin Nelson.
No information had been provided to you about two key eyewitnesses?
Not that I can recall, no.
And had you been given any information about the status of the officers or what PIRC were considering at the time?
I certainly wasn't aware that there was any consideration of detention at that stage.
Perhaps you should explain detention, something that existed in 2015 compared to arrest.
Yes, that was the stage effectively before. At the stage of detaining, that's when you would move to the status of a suspect and allowed the opportunity for the interview under caution.
Right. But to be detained, you would have to be a suspect.
Yes.
What briefing had you been given for this meeting with the Lord Advocate?
I can't recall at this time what briefing I'd been provided with in advance of going to the meeting. I certainly was aware that the officers had still not provided any statements, and my understanding is that the meeting had been convened to discuss those circumstances.
If we move to the top of the page, I'll come back to this entry in a moment, but do we see that there is some initial discussion about the fact statements hadn't been provided by the officers?
Yes.
So this is about 11 days after
Yes.
the death of Mr. Bio.
Yeah.
I think we're aware that officers had decided not to give statements and to seek legal advice.
Yes.
And had you been given a briefing about the circumstances surrounding the absence of statements?
Yes.
Clearly there's mention there about the officers being suspended. Do you remember the discussion about suspension?
I don't know, I'm sorry, I don't.
Right. Do you remember the discussion about the absence of statements?
I do.
And what were the concerns of PIRC at that time about the absence of statements?
It was the first time that this had ever happened, and I think there was a degree of surprise about it, frustration. There had, to that stage, been an expectation that officers would provide statements in circumstances such as this, or initial accounts in circumstances such as this. And I think there was a balance or a consideration as to officers being afforded their opportunity to be treated as other members of the public, because I think the concerns being expressed were that they were potentially concerned of any potential around incrimination, and like anyone else, both witnesses are not able to be compelled to speak, even if they're suspects. Similarly, they cannot be forced to provide a statement or incriminate themselves.
We've heard evidence that PIRC were keen to know what had happened at Hayfield Road on the 3rd of May.
Yes, that's correct.
That there was an issue determining who had done what in terms of the individual officers.
Yes.
And that was a hurdle, if you like, that investigators were keen to get past.
Yes.
Were you aware of all of that when you went to see the Lord Advocate that
Yes.
day? And my understanding is that PIRC were quite keen to find a route through that difficulty that they were facing.
Yes, and my understanding is that that was really the essence of the meeting.
Right. And, excuse me, that there was PIRC were thinking about different ways that they could find some sort of route through.
Yes.
So what solutions to this problem were you thinking about when you went to this meeting with the Lord Advocate?
I can recall discussion around the potential for recognition on oath. There was also the discussion of around whether the Lord Advocate would contact the Chief Constable with a view to any assistance in securing those statements.
Tell us what a precognition on oath was.
It's where someone can be ordered to appear in court and provide evidence under oath.
What consideration did you give to using that as an option?
Well, the PIRC wasn't enabled to undertake that, and there was discussion around whether COPFS would be in a position to advance that.
And were they?
Well, they didn't do it.
So was this issue discussed at this meeting with the Lord Advocate or at other meetings with Crown Office?
It was discussed at this meeting.
And what were the reasons, as far as you're aware, as to why the Crown decided not to seek a precognition on oath?
I can't recall why they didn't do that.
Was that something that PIRC would have supported if the Crown had been willing to move it forward?
Yes. Mm-hmm.
Did you consider interview under caution as a solution to finding a route through the difficulties with the absence of statements?
Not from the information I had, no.
Did you consider discussing the information you had with the Lord Advocate to see whether the Lord Advocate took a different view about the status of the officers or whether interview under caution was a possibility?
There was discussion around the status of the officers, and the Lord Advocate's view, that he stated quite clearly that in the circumstances that he considered them to be witnesses.
And so at that stage, if it was the Lord Advocate's view that they were witnesses, did PIRC not take the idea of interview under caution any further?
I think that's right, yes.
Was there any attempt to raise with the Lord Advocate about the information that was available from the statements with Ashley Wise and Kevin Nelson?
I don't recall any discussion about those two witnesses at this meeting.
Did you not consider there might be merit in addressing the Lord Advocate about those two statements?
Well, as I say, I don't think I was aware of the content of those two statements.
You weren't aware of the content of them
At that time, no.
Can I just ask you something, Ms. Frame? As a generality, just setting this case to one side,
Yes.
in any investigation where suspicion begins to crystallise on somebody,
Yes.
is it the PIRC's decision to change the status, or do you have to go to the Crown?
No, I think that the decision is generally, or has generally been made by the lead PIRC investigator.
Thank you.
Thank you. Can we go back to the entry we looked at a moment ago? We may need to detain and interview under caution. This was a comment by Mr. Mitchell. And it said under there, this is a carbon copy of the Duggan scenario. Do you remember what that part of the discussion was about?
I don't recall this being raised at the meeting. However, I have had discussions which would chime with Mr. Mitchell's comments about the Duggan scenario.
Tell us the relevance of the Duggan scenario to the investigation into Mr. Bio's death.
Yes, I discussed this with the IPCC and...
Is that the English
that's
equivalent of your role?
more or less, yes. And in that case, the officers refused to provide statements other than in writing, which delayed the IPCC investigation, I was told, for approximately a year.
They didn't provide statements for 1 year other than in
Well,
writing.
the delays, yes.
So they wouldn't give oral, verbal statements.
Yes, that's my understanding.
And so in relation to the reference to carbon copy, is that in relation to the difficulties in relation to statements that's being
I
referred
think,
to?
well, I would assume that's what he's referring to, yes.
You don't appear to contribute to that aspect of the discussion. Was there a reason for that?
To the Duggan scenario conversation?
To the comments made by Mr. Mitchell, may need to detain and interview under caution. This is a carbon copy of the Duggan scenario.
No, I didn't contribute to that. I was aware of the background around Duggan. We had discussed that. There had been various documents circulated within the investigation team about the Duggan case. So I was familiar with it, he was familiar with it, and we were aware that the investigation team generally were familiar with those circumstances.
And then beside the asterisk it says, but independent confirmation of his actings. Do you remember that as that element of the discussion?
No, I'm sorry, I don't.
Right, thank you. Can we move on to the next page? Page 2. If we can look at a comment made attributed to Mr. Mitchell, which is further down. There we are. SPF position is that they employ Peter Watson, but they disagree with legal advice. Should be for each individual officer to decide. Do you remember that part of the conversation in the meeting?
No, I recall some general comments in relation to the officers being represented, but I can't recall any particular detail around that.
And then underneath that, I'm not entirely sure what the third word is, but it says, I am summing this up because AA came to me and because it was discussed at Cabinet. AA, I understand to be a reference to Amar Anwar, who was representing the family at this time. So it was discussed at Cabinet and they are keen to avoid another Baltimore. What was your understanding at that time about the reference to avoiding another Baltimore?
Well, I think many people at that meeting were aware of the a general unrest following a death in Baltimore and civil unrest and rioting, as I recall.
And was that in relation to the death of a black man
I
at
think
the
it
hands
was.
of the police?
Yes.
So was everyone at the meeting on the 14th of May aware of the recent events in Baltimore?
I can't speak for everybody. I was aware.
You were aware. Right. And the matter had been, Mr. Anwar had spoken to Crown, and this matter had been discussed in Cabinet. Were you aware of that?
No, I wasn't.
And then we see, just 3 lines down from that, there's a reference to LA. PM was far too quick. Do you see that? Do you remember that part of the discussion at the meeting?
I don't. No, I don't.
Did you have any views at that time about the speed at which a post-mortem was carried out?
I recall I was surprised. I was surprised largely because it was the holiday Monday. I was surprised that there were pathologists even available on the holiday Monday.
Insofar as the PIRC investigation was concerned, I appreciate you were only at work briefly on the Monday.
Mm-hmm.
Would you have had any concerns at that time about the post-mortem being delayed slightly to accommodate the family attending for an identification of the body?
Well, I think that was something that I was flagging up to Crown Office to allow them to consider that.
This was on the 14th of May,
Sorry, no, not on the 14th, on the 4th, I think.
when you spoke to Mr. Green.
Yes.
We've heard evidence that in order to justify use of force, all officers have to justify every single use of force that they adopt during their operations,
Yes.
their daily work.
Yes.
So if, for example, there are 3 baton strikes, they have to justify using each individual one of those 3 baton strikes.
Yes, I'd agree with that.
So it's not enough for officers to simply give a general justification, it has to cover all 3.
Mm-hmm.
If that justification is not given, then it could be considered excessive and not legal.
Yes.
Can I ask you some questions about when you did get the statements of the officers, which was not until the 4th of June?
Mm-hmm.
So the meeting we've just been looking at was the 14th of May,
Yes.
and the statements from the officers came on the 4th of June,
Yes.
some weeks later. And we've heard evidence from your investigators at the time that arrangements were made, and a number of them attended at Scottish Police College, and investigators interviewed them and took their statements.
Mm-hmm.
And we've heard evidence that Mr. McSporran and Mr. Little were effectively in a coordination role that day.
Mm-hmm.
I'd like to ask you to look very briefly at some statements that were obtained that day on the 4th of June. And again, look at a snapshot of some information that PIRC had available.
Okay.
The first 2 officers on the scene in Hayfield Road on the 3rd of May.
Mm-hmm.
Let's look at the statement of PC Payton, who gave a statement to PIRC on that date, PIRC 00262. There might be a technical glitch. Well, I wonder if we could maybe see something else on the screen, because I'll move on, I'll come back to the statements. PS, oh, here we are. Excellent. So we're looking at a statement here from Alan Payton,
Mm-hmm.
who was one of the first officers on the scene, given on the 4th of May,
Yes.
2015, and it was taken by Alex Maguire and in the presence of Ricky Casey.
Yes.
And I'm interested in pages 4 and 5. And page 4 starts with the paragraph, "I think it took me." That's the one. Can we look more, just under halfway down this page, at the paragraph, it says, "I was straight out of the passenger side door." Keep going, please. There we are. So you see that big paragraph in the middle of the page?
Yes.
"I was straight out of the passenger side door of the van." This is the statement taken from PC Peyton on the 4th of June.
Okay.
"I immediately took my CS spray out of my vest. I continued to think that he may still have been in possession of a knife, and I wasn't taking any risks." So he goes on to say, I've already said, "I was still conscious of the fact that just because I could see his palms, he might still have a knife in his waistband or secreted somewhere about his person. With my spray in my right hand and pointing in the direction of the man, I shouted loudly and very clearly, 'Get down on the ground.' The guy was walking towards me and completely ignored me. He kept walking towards me with his palms out, and I remember thinking how crazy he looked and as if he was on a mission. I was in genuine fear for my life, and at this point, I pressed my red emergency button and shouted loudly and clearly, 'Get down on the fucking ground.' My shouting and my pointing of my spray had absolutely no bearing on him, and he kept walking towards me, ignoring me, as if he was in a one-track mind. I was terrified and thought I was going to get attacked by him. When he was about 10 feet away from me, I sprayed my CS spray towards the boy's face." And he describes the impact of that. Next page, please. There's a reference at the top of the page to Craig. This is PC Craig Walker, who was the other officer
Yes.
who was first on the scene with PC Peyton. Craig came out of the van, came round to the front. He was pretty much on with the boy on the boy's left side. Craig also had his spray out. I remember seeing it was Pava. It had the red top on it, and Craig also discharged it towards the boy's face. And some of it hit the boy, but it blew into my face. And then the next sort of 2 paragraphs in, at no point did he hear the boy say a single thing. You see that? And then I'd like to move on to the statement from Craig Walker, which is PIRC 00265. I'm interested in pages 5 and 6, but if we look at page 1 first of all, so this is PIRC 00264. Sorry. While we wait for that next statement to come up on the screen, because I'm interested in the use of CS Pava and CS and Pava sprays.
Okay.
When the officers came out of the vehicle in relation to the use. And you'll have seen that Mr. Bile was said at that time to have his palms out. We've heard a knife wasn't visible, but clearly PC Peyton was of the view that it could have been secreted on his body at that time. So this is, we're waiting for PIRC 00264. While we wait for that, I'll tell you the section I'm interested in. Again, it's a statement from PC Walker. If we look at page 1 first of all, it's a statement from PC Walker, 4th of June 2015, taken at Scottish Police College by Keith Harrower and a trainee investigator, Lynn Ungi. If we can go to page 5, please. And if we can look at the paragraph that begins, "As I was in the process of exiting the van," here we are. I could hear PC Peyton shout a command at him, "Stay where you are, don't move," or words to that effect. Do you see that?
Yes.
So he talks about PC Peyton standing in a spray-drawn position, spray in right hand pulled back towards the body, his left hand fully extended in a fend-off position. He was in a defensive stance. Peyton was standing directly in his path, and he walked round, and he was looking over to Gage's reaction. There was no reaction at all. He just kept walking and was about 6 feet away from him, directly in front of him. As I moved across the front of the van, PC Peyton took a couple of steps backwards and shouted again at him, "Stay where you are." The man said nothing at all and kept walking. PC Peyton was having to work to keep the gap. He then sprayed him with his CS spray. I could see the spray go into a large cloud in front of his face. I'm not sure if any of the spray hit his face. The wind was against PC Peyton and it just dispersed widely. Then can we go to the bottom of that page? As I got past the front of the van, he turned towards me after I shouted at him, "Stay there," or words to that effect. He faced me. I had my PAVA in the spray drawn position I described in my right hand. I also had my left arm extended, pointing at him. I was standing in the defensive position. I shouted, "Drop your weapon," or something like that, but there was no response from him. I still thought he had a weapon concealed on him, and he wasn't giving verbal or non-verbal communication at all. I immediately discharged my PAVA spray at him. I didn't issue a warning, re the discharge, but it would be obvious to him, as I had it up in front of him in plain sight, and it has a bright red lid on it. So can I ask you to consider just the use of PAVA spray and CS spray by PC Peyton and PC Walker
Yes.
when they get out of the van? And can you bear that in mind as I ask you to look at another document?
Okay.
And this is a use of force SOP, a standard operating procedure, and it's PS 10933. Now this, as I understand it, is, I'm interested in section 4.6 and 4.7. So this is the use of force standard operating procedure we've heard is used by Police Scotland at the time. It was in force at the time. And section 4.6 is called profiled offender behaviour. And I'll just very quickly run through this with you. So profiled offender behaviour, it encompasses the actions and behaviour of the subject and comprise of the warning and danger signs they exhibit coupled with impact factors. Profiling a person's behaviour may assist in determining an officer's reasonable response. It can be subcategorised, and we've looked at this previously, but I'll just refresh your memory on this. There are a number of different levels of profiled offender behaviour. There are 6. Level 1 is compliance. Level 2 is verbal resistance and or gestures, which includes shouting, swearing, verbal challenges to requests or instructions given. It normally includes non-verbal gestures and posturing and can consist of warning and danger signs of potential attack.
Yes.
Level 3 is passive resistance. It's typically used by demonstrators but not exclusively. It's non-active conduct with no compliance to lawful instruction. Level 4 is active resistance, a more physical form of resistance in that the subject is actively doing something to prevent or obstruct an officer from carrying out their duty. Although it's physical, it falls short of an assault. Level 5 is assaultive resistance. It's a deliberate intention by another to cause a physical effect upon a person, directly or by indirect means, assault by menaces. And then level 6 is serious aggravated assaultive resistance. This is the highest level of resistance encountered, which generally involves the intended use of weapons as part of the attack, where the perceived threat is that of serious injury or is life-threatening. The statements of PC Peyton and PC Walker talked about Mr. Bio having his palms out, no weapon visible, but he was not responding to commands. He was not responding to the spray ultimately, but he didn't shout. He wasn't swearing. He wasn't being aggressive towards the officers at that stage when they get out the van. Can we look at levels 1 and 2? We've heard that at that point, that moment in time, his behaviour was not compliance, but could have been up to level 2, verbal resistance and or gestures. Although there was no shouting, swearing or verbal challenges to requests, it could have been between 1 and 2, his profiled offender behaviour. Let's look at section 4.7, which is the reasonable officer response. By combining the elements of profiled offender behaviour and impact factors, it affords the officer or staff the ability to quickly assess the threat and to make an informed decision to adopt appropriate tactics from a range of force options in order to deal with the situation in a controlled, justifiable and accountable manner. And I think you agreed earlier that it's necessary for officers to show that they've precluded other options.
Yes.
And they've used the absolute minimum force necessary.
Yes.
Now, I'd like to look at level 4, please. There are 5 levels of reasonable officer response in this SOP. 5 is deadly or lethal force. So that's the top level that an officer can adopt. Level 4 is defensive tactics. These tactics are generally perceived to be strikes, whether delivered by means of empty hand techniques or baton strikes, but also include the more robust defensive handcuff techniques and the use of CS incapacitants spray. So use of a spray is a level 4 response by an officer. We've heard from PC Walker, he didn't give a warning before he discharged his spray.
Yeah.
His statement does not include any reference to PC Payton giving a warning, and PC Payton's statement does not mention giving a warning to Mr. Bio. And they have got out their vehicles with their sprays and used their sprays at a time that Mr. Bio was palms to the front, no visible weapon, no communication. Is there an assumption that PIRC adopted that all use of force by police officers was lawful?
No.
So it remained the case that it was for the officers to justify each use of force.
Yes.
Did PIRC assume that in the absence of a justification that the use of force was unlawful?
Sorry, could you repeat that?
If there is no justification given by an officer to PIRC as to the use of force, was there an assumption or a presumption that it was unlawful?
I don't know if it was. I don't know how that was treated.
Have you any idea how it was treated by your investigators?
I don't know.
What was your view? If the officers did not provide justification for a use of force, did you consider that to be unlawful use of force?
Yes, because it does require to be justified.
So, on the face of this description from the officers on the 4th of June, where we have an SOP, we've heard, tell me if you take a different view, that the behaviour, profiled offender behaviour of Mr. Bio, initially, as the officers got out of the vehicle, was 1 up to 2. And the officers have gone straight to using CS and Pava spray, apparently without warnings. What would your view have been in relation to that use of force?
It seems to have escalated potentially beyond the behaviour that was being demonstrated.
Do you mean excessive use of force? When you say beyond, what do you mean?
it seems to have moved quickly to a force that does not accord with the circumstances that are being presented.
Thank you. If officers justify some uses of force but not others,
Yes.
is that enough? Was that enough for PIRC?
No.
The chair asked you a short time ago whether it was for PIRC to assess whether each use of force had been justified, or was that for the Crown? What was your answer to that? I think he was talking about, would it be up to the PIRC to decide?
And just for clarification, that was in the context of changing the status
Yes.
from a witness to a suspect.
Sorry.
Yes.
Let me ask you something else. Let's look at paragraph 727 of your inquiry statement. I've asked that question poorly, I'm sorry. Let's look at 727. I think this might make it more straightforward. So this is your inquiry statement. It's one of the later paragraphs. I've been asked if PIRC investigations following deaths in custody would always involve an analysis of officers' actions. Do you see that?
Yes.
Yeah, so it's also on the screen if you prefer. I've been asked if PIRC investigations following deaths in custody would always involve an analysis of officers' actions against the terms of SOPs.
Yes.
Usually there was a comparison between what the SOP detailed and the actions taken. I can't remember whether or not there was always a written analysis of that, particularly in relation to the use of force SOP, as determination of whether the actions were legal, proportionate or necessary was a matter which Crown Office required to determine.
Yes.
So that was not something that PIRC had to determine or decide upon themselves.
No.
But you, in terms of your expectations of your investigators, you would have expected there to be some sort of comparison between what you knew of the officer's actions and the requirements in the SOP relevant at the time.
Yes, and that was regularly done.
And you say there, you can't remember whether it was always a written analysis. Would you have expected there to be some record made of that analysis?
Yes, I think there probably should have been some comparison that was captured to detail whether it accorded with the appropriate action.
And would that have been a good practice to record that type of analysis if it was carried out?
Yes, it would be best practice.
In terms of if there had been a written analysis carried out, where would that have been noted?
In the report?
I'm talking about if an officer had carried out that comparison exercise.
If an investigator had done that?
If an if an investigator had done that, would you have expected that to be noted in a particular location?
Well, again, I would probably have expected that in the policy log.
Right. And that would have given the decision and also the reasoning behind it.
It would.
And if I was to say to you that we've looked at the policy log and there is no such comparison has been carried out, certainly nothing that was noted there.
Yes.
And we've not heard any evidence of that type of comparison. Would that concern you?
Yes, I think it would be surprising and disappointing.
And in terms, thinking again about adequacy of the investigation, we were looking at Article 2 issues. Does that cause you concern that that wasn't done?
Yes, I think it would have been best practice for that to have been recorded.
Right. And I think you've said that having looked at the 4.6 profiled offender behaviour and the reasonable officer response, you can see
Yes, a
disparity
discrepancy,
there,
yeah.
a discrepancy. And is that something you would have expected to be done after the 4th of June when the officers' statements were available?
The comparison against the SOP?
Yes, yeah.
Well, yes, that would have been appropriate to do that.
How quickly would you have expected that sort of work to be done?
That would very much depend on what other priorities were being undertaken by the investigation team. But I would have thought that with the detail that was provided in the statements, it would have been relatively straightforward, particularly by investigators who had a background knowledge as well of what the SOP expected.
And what would you have considered a reasonable period for your investigators to carry out this comparative work?
Well, as I've said, depending on the other priorities, but I would have thought certainly within a week or two.
A week or two of the 4th of June?
Yes.
Thank you. And just to be clear, where it says in your statement, you make reference to the use of force SOP, the determination of whether the actions were legal, proportionate or necessary, is that essentially a reference to whether the actions were justified as being reasonable, proportionate or necessary?
Yes.
And that is required in order for that use of force to be legal?
It is, yes.
Thank you. I'd like to move on to the final post-mortem report, which later became available to your investigators. And that was on the 18th of June. So around 2 weeks after the officers' statements had been made available to you. And if we look at PIRC 01445, and if we can look at page 2, do you see it says final report, date issued 18th June 2015?
Yes.
And it's in relation to Mr. Bio. And if we can move down the page, please. The medical cause of death is given as 1A, sudden death in a man intoxicated by MDMA, ecstasy and alpha PVP whilst being restrained.
Yes.
And the date of the autopsy is the 4th of May 2015. And the examining doctors were Dr. Kerry-Ann Shearer and Dr. Ralph Buhadir. And
I
was
think, Ms. Graham, if you're going into the
Yeah.
post-mortem report, this is probably a good time to
Thank
stop
you.
for lunch. So we'll sit again at 2 o'clock.
Thank you very much.